Welcome back to our next little vignette explaining what's going on with respect to the abortion law the legislature passed this past year, the governor's abortion law, and trying to help you understand where the case now is and what's happened, particularly with this flurry of orders that took place right around Thanksgiving between the Sixth Circuit and the district court. As I mentioned in our previous videos, if you've not watched them, the issue that's right now in front of the court is whether or not the reasons ban, the ban on abortions because of the child's sex or race, ethnicity, or a Down syndrome diagnosis. That's the issue that's right now in front of the court, not the part of the law dealing with the heartbeat and various gestational ages. This is the part of the law that says, I don't care what stage of the pregnancy is. You know, if it's 3 days, you can't abort the child because of race, ethnicity, /sex, /Down syndrome. Okay? That's the situation. Now, what the trial court had done with respect to the gestational ban, the second part of the bill, is he had not looked at any of the findings that the legislature made, which were extensive, as to why it was enacting the law. And the court simply said, hey, these gestational bans are unconstitutional because some of them apply prior to fetal viability. Now, fetal viability is the standard that came out of the case called Planned Parenthood versus Casey, where the court said that prior to the fetal viability, the state cannot impose an undue burden on a woman's liberty right to make an abortion decision. Now, what we mean by fetal viability is that the fetus has progressed to a stage of gestation at which, with medical assistance, it could survive outside the womb. And so, in Casey, the court said prior to fetal viability, the state, the government, the legislature cannot put an undue burden on a woman's right to make an abortion decision. It didn't say that abortion was banned completely. It just said you can't put an undue burden on the woman. So the court looked at that gestational period and said, hey, it kicks in at the heartbeat, then goes to 8 weeks, 10 weeks, 12 weeks, 15 weeks, so on and so forth. That law on its face applies prior to fetal viability, so it is unconstitutional, period, no questions asked. He didn't look at whether there might be an undue burden. He just assumed it was an undue burden. Well, that was an error. But the court did not look even at any of the findings that the legislature put into the law. If you'll recall, when the legislature had before it the first fetal heartbeat bill in 2019 that passed the House, there were no findings at all. And I objected to the bill. And I said, hey, you need to put findings in this bill. You need to explain exactly what you're doing and why you're doing it. And well, the House didn't choose to do that. And that led to the Senate hearing in 2019. Well, when the governor filed this bill, thankfully, he listened to that testimony, and there are extensive findings in this bill. But the district court, originally, on that part of the law, the gestational part, didn't even look at the findings. So it's irrelevant. You've banned an abortion prior to fetal viability, unconstitutional. Now, that case is up in front of the Sixth Circuit, along with this reasons ban, the part that deals with the discriminatory abortions for race, ethnicity, sex, and Down syndrome diagnosis. Now, we filed an amicus brief on behalf of 33 legislators in the Sixth Circuit and pointed out that one of the things the court did that was erroneous was it didn't even look at the findings to determine whether the legislature had a legitimate interest in acting in the way that it did. It just disregarded them completely. Okay, that's important. So here's what happened. We're now in front of the Sixth Circuit. The Sixth Circuit says that the reasons ban, discrimination ban, is not unconstitutionally vague, as I mentioned in a prior video. Send it back to the trial court to decide whether or not that discrimination ban violates Roe and Casey. Well, here's what the court said, and I believe the amicus brief we filed made a difference because the court said this, and let me quote, "The legislative findings supporting this section of the bill articulate the state's legitimate interest in preventing discrimination based on sex, disability, and race, and plaintiffs don't argue that it's not legitimate on its face." Great. For the first time, the federal district court actually looked at the findings to find out why the legislature was acting and what its interest was and whether or not its interest was legitimate. So praise God for that. I'm glad we were able to call that to the court's attention. You can't just dismiss those findings. Now, unfortunately, the reason the court said that it was not going to temporarily restrain the state from enforcing the law and would consider at the preliminary injunction hearing whether to continue to allow the state to enforce the law. And again, you might want to watch our first video about the difference between temporary restraining orders and preliminary injunctions. And right now we're at the preliminary injunction stage. Here's why the court said the law was not an undue burden on a woman's right to abortion. Now again, I'm speaking only here of the discrimination ban, not the gestational ban. The court said the discrimination ban was not an undue burden, and here are the reasons. I'm going to quote. The court said, according to the defendants, the statute for the discrimination ban will not be enforced unless the physician, quote, knows the abortion is being sought because of a prohibited reason, and the defendants are conceding the physician is under no duty to inquire about the patient's reasons for seeking the abortion. Defendants represent, that's the state, a physician must be aware that the abortion is being sought because of the child's race, sex, or Down syndrome diagnosis. And oblique references to race, sex, or advanced maternal age would be insufficient to establish knowledge under the statute. The statute will not be applied, this is again the district court saying, it's not going to be applied when a patient merely mentions the words sex or race. So the court says, based on these representations, which are by the state, the plaintiffs have not shown at this juncture, now this is the temporary restraining order junction, that this section of the law is unconstitutional and I need to restrain it. So in other words, what the court was saying is the state has essentially said this is a don't ask, don't tell policy. As long as the woman doesn't go into the doctor and say, I want to abort this little boy because I want a girl, well, the doctor doesn't know. He can perform the abortion. Does the doctor need to ask why she's having the abortion? No. The state conceded he has no duty to even ask why she wants the abortion. She wants it, she can have it. So that's why I say it's a don't ask, don't tell policy. Now, I would just ask you how effective this law will be in preventing any of these abortions. When the woman doesn't have to explain why she's giving the abortion, and the doctor isn't required to ask why she's having the abortion, and whether or not, even if she did, would an abortion doctor write that in his notes? Woman wants to have an abortion because it's a boy and she wants a girl. I don't think an abortionist would probably be so forthright and honest in putting that in their records. But in any event, that's what the court ruled. Whether the law will actually save any baby's lives or not, I don't know. To be honest, I probably doubt it. I would suspect Planned Parenthood will say, now, ma'am, you need to know that if you want to have this abortion because of the child's race or ethnicity, sex, or a diagnosis or possible diagnosis of Down syndrome, it'd be a crime for me to perform that abortion. So is that one of the reasons you would want to have the abortion? Planned Parenthood can prime the woman to make sure she doesn't give an answer that's prohibited by law. And of course, if she doesn't get the hint, he can refer her to another abortionist. But anyway, that's why the district court said that the law was not an undue burden on the woman, because she never had to explain why she was doing the abortion and the doctor never had to ask. I hope that's helpful.